All right, good afternoon, everyone, and thank you for joining us for Legal Aid's Making Justice Real series. This is session 4 on the eviction crisis. And we are so happy to have Beth Mellon Harrison from Legal Aid and Phil Horton from Arnold and Porter with us today to talk about all their work and landlord-tenant issues. We will go ahead and get started. As I said, please use the chat function to ask questions during the presentation.
Hello, everyone. Caroline, can you go to the next slide for me to get started? Thank you. My name is Beth Harrison. I'm one of the supervising attorneys at Legal Aid, and I head up our eviction defense work. And I will say we have a team. I say that, but everything at Legal Aid is very much a team effort. We have a group of 24 attorneys and support staff doing this work. And are fortunate to have just a great group of folks supporting eviction defense and the other work we do. So I'm just going to briefly talk, I am going to try to go through some of these slides a little quickly because there's a lot of information about the affordable housing crisis in the district, kind of as it is and was before COVID-19, and the work that Legal Aid plays along with other eviction defense legal services providers. And then also just a little bit about what is happening now with COVID-19 and what we fear is going to be a true eviction crisis that's going to hit the district in the coming months. Next slide. And yes, thank you. So first of all, I think it's helpful if you don't know anything about housing to have a little grounding on affordable housing and just a little understanding of what's going on in DC. So the U.S. Department of Housing and Urban Development uses a marker that you should pay 30% of your income for your housing costs. That includes rent and utilities if you're a renter. That's true for a homeowner too. And if you apply for a mortgage, the marker of 30% to a little higher is something that lenders look at in terms of your total housing costs. And so if you just look quickly at what that means, so if you're in the bottom 20% of households in terms of income in the district, you have an average income of about $10,000 a year, you can only afford $253 a month in rent. On the other hand, if you're in the top 20% of households, you can afford nearly $8,000 a month in rent. And frankly, I think the gap between those two numbers almost tells you everything you need to know about the affordable housing crisis in DC. We have an incredible gap in income, in wealth, and of course, in the district as elsewhere, that cleavage falls along racial lines. And so Black households and Latinx households have less income, less wealth, are much more likely to face a crisis in terms of affording their housing. Next slide, please. So DC is the 7th most expensive market in the US, and our average rents right now are above $2,000 a month for units. And what I think is most striking about the affordable housing crisis, which may be completely logical or intuitive to you, is how much the burden falls on our households with the lowest income. So for these purposes, studies have been done about the bottom 30% of households by income. They pay, 2/3 of them pay half or more of their monthly income towards rent, and half of them pay 80% of more or more. So for those households, almost all of their cash income is going towards their rent every single month. And I apologize, it looks like I left off the last part of the bullet point here, but the majority of these households are households headed by a person of color, primarily in the district, Black households. Next slide, please. And so I know a lot of folks then say, well, don't we have all these affordable housing programs? There must be things out there for tenants in need. So DC has lost half of our affordable market units. Sometimes folks talk about naturally affordable units, so units that might be in older buildings or in certain parts of the district. And half of those have disappeared in the last decade. And that only leaves about 30,000 left. That's as of a few years ago. So I think that number is probably worse at this point. And then we have about 30,000 subsidized housing units. That number is rapidly shrinking. And actually our public housing stock, there are proposals to demolish several thousand of those units, for example. And then we have a centralized waiting list for subsidized housing in DC, and there are 40,000 families on that list. It's actually been closed for 7 years now. So right now, if you are a family, you become homeless, you need to go on that list, you cannot. And that has been true for 7 years. And the list is so kind of backed up, and subsidized housing, new units or units that become available are so scarce that homeless families who get a preference in the system, it can take them 10 years or more to come off of that list. Families that are not homeless essentially never come off the list. And so subsidized housing and low rent housing really are not options for most district residents. Next slide. The other thing I will say about subsidized housing is if you get evicted, you often lose your subsidized housing. So the crisis that eviction sets off for your family is quite dire. And then in terms of programs we have to produce affordable housing, I'm not going to go into the details on this slide. Actually, I will just say the bottom line is the biggest need is those families in the bottom 30% of income. There are about 40,000 families in the district who need affordable housing in that group. And we have lots of programs to build affordable housing for folks at higher income levels, up to 80% of our average income in DC, which is pretty high in DC. But we do not target that affordable housing production to those families at the bottom who most need it. We tend to build it for families who are more in the middle. Everyone needs affordable housing, don't get me wrong, but the biggest need is for those families at the bottom, and we are not doing what we need to help them. Next slide. So, and you can go on to the next one. So then we get to eviction. So what is eviction court like? And I will say Phil has experience in landlord-tenant court himself. So at this point, there are about 30,000 eviction cases that are filed every year. There are only 2 judges, 2 courtrooms that hear those cases. And so I think we have some summer associates on the line, some folks who are in law school and not yet graduated. I would just encourage you, if your law school experience does not otherwise lead you to this, and of course you can't do this at the moment in the same way, is to, when these courts are kind of operating in normal ways, go to one of your local courts, a high volume court, to see what it's like. It's a really important experience in my view for any lawyer to have, even if your practice will never take you there. I hope if you have a practice as a law firm attorney or otherwise not involved in this kind of work, that you will consider pro bono cases to get you into some of these high volume courts. They are filled with low income residents, people of color. In DC, it's primarily Black tenants who are in court, and they are just run in a way that does not express dignity or respect for the litigants at all. They are very intimidating, things happen very quickly, and there just are not enough resources available to help folks who do not have attorneys. And so in DC, what we see, and this is common in the US, 90 to 95% of the landlords in these eviction cases have attorneys helping them. And even with more resources that we've gotten in DC, we only help about 10% of the tenants. And DC is interesting because we have amazing, by kind of national standards, amazing tenant protections on the books under our law. But if you don't have an attorney, it's extremely difficult for you to access those rights. So I'm going to talk in a minute about what happens to tenants we represent or pro bono attorneys represent. But most tenants, the reality is a large group of them don't come to court. A default is entered and the eviction process starts. And then for another large group of tenants, they do not have attorneys, and they end up signing, and I'm going to pause after I say this and ask Phil if he wants to jump in and say anything. But they sign what are known as consent judgments, where on the first day of court, typically, the tenant meets with the landlord's attorney, signs an agreement that enters judgment against the tenant, but says we will not execute on that judgment so long as you pay back every single cent that we say you owe us. You pay it back really quickly. And typically in those agreements, tenants do not get repairs of any kind, even though we know that if you ask those tenants, probably 2/3 to 3/4 of them, when they're sitting there in court, have repair needs in their home that have not been addressed. And that's because, of course, they are going up against a seasoned landlord attorney who's a frequent player in the court and knows the judges and knows the clerks, you know, is basically saying to them, this is it. You sign this, or I go into the courtroom and I ask the judge to start the eviction process against you. And
Beth
so, yeah.
Beth said she was going to ask me to comment. Beth, I think, is too kind about these. These forms are an abomination. The court can process this large number of cases fast for the court's convenience. They are an absolute abomination. I've been trying to get them done away with since the 1990s, but they help the court process their cases, so they are still there. Years ago, I was supervising an associate doing one of these cases. He was going off to meet with the landlord's lawyer. I said, he's going to ask you to fill out one of these forms, which at that time was called a Form 4. I said, when he asks you to fill out one of these court forms, here's what I want you to do. Laugh in his face. He came back from the meeting. I said, how did it go? He said, he asked me to sign one of those forms. So I laughed in his face. And he actually came back with a far, far better settlement. These forms are a scandal. Sorry, Beth.
No, that's great, Phil. And I will just add a little further commentary to say Phil is making a good point, which these are actually court forms. These are not private agreements written by the landlords. They are court forms that, for example, the repairs are not part of the agreement. It's a special extra page you have to know to ask for. And so I think when we talk about, as many of us are now, systemic inequality and racism and how we see those reflected in institutions, as I said, this is a court where primarily the litigants who come in are people of color, low income, do not have, you know, power and influence in many ways, and the court is designed in this way, and it is designed for the landlords. And that's something that's happened over many years, and I'm not going to pretend it's easy to change, but it is a reality that I think the court needs to grapple with. And I know the current chief judge came in and said as much and said, look, I realize most residents of the District of Columbia who are encountering the civil legal system are encountering a court like this. You know, and then the criminal system is a whole other ball of wax. But this is what the civil legal system looks like for most residents of DC when they encounter it, and is not a pretty picture. So the next slide, I think, has just a little graphic that I'm mostly going to skip over with very small print. But the red chunk, or the kind of dark maroon chunk, represents cases that are dismissed. A lot of the cases are actually dismissed because the tenant pays up. And in DC, one of the rights tenants have is to pay up all the rent they owe at any point before the eviction and be able to stay. But you can see of the remaining cases, the green chunk is these consent judgments. That blue chunk is defaults. And so a large portion of those cases are taken up by one or the other of those outcomes, and those are not good outcomes for tenants. Next slide for me, please. So what does legal aid do? I think the first point I want to make is we partner with a lot of other organizations. We cannot do this work alone. And so I mentioned the team I'm a part of. The Counsel of the District of Columbia expanded funding for eviction defense in 2017. It had been about $1 million a year. It is now $4.5 million a year. And that's allocated by an organization called the DC Bar Foundation. So we, Legal Aid receives that money along with Bread for the City, the DC Bar Pro Bono Center, Legal Counsel for the Elderly, the Neighborhood Legal Services Program, and Rising for Justice, 5 other providers. We also, and perhaps relevant to those of you who are thinking, who are summer associates thinking about going to a law firm in DC, we have a project that we call the Housing Right to Counsel Project, where we partner with 20 law firms in the federal government to refer out cases to pro bono attorneys, eviction defense cases. And that's something else where the 5 providers in Legal Aid all collaborate. And then Legal Aid alone, just to give you a sense of scope, we represent about 400 families a year in eviction cases, and then we do other housing work as well. I will just mention briefly, we also help tenants in subsidized housing. So where the government is helping pay the rent and the tenants paying income-based rent at that 30% level, generally, with various issues that those tenants encounter with their subsidized housing and trying to keep their subsidized housing. We also work with tenant associations to deal with issues from conditions to fighting large rent increases to working with developers if their building is being sold to try to preserve it as affordable housing. One of those amazing rights that tenants in DC have is called the opportunity to purchase, or a right of first refusal. And so we work with some of those tenant organizations, tenant associations who are trying to exercise that right and partner with the developer around the future of their building and keeping it affordable. And there is a lot of coordination and collaboration that happens amongst the eviction defense providers, and Legal Aid is a part of this. So we have an in-court same-day representation model through courthouse offices that we have. Recently, the court has commented on kind of why is this same-day model needed, or why do so many tenants only come to you the same day of court? And I will say the answer is actually that the court rules, statutory rule, says tenants only have to be served about a week before their court date. So I am a person with many privileges and advantages, and if I got a court paper today to appear in court next week, I promise you I would not have time to go talk to an attorney ahead of time, and I would just be panicked. And I would be lucky if I could show up to my court date and figure out, how to make that happen. And so, many tenants seek our help the same day in court because they have had such little notice and they have many other things going on in their lives. And so we coordinate with the other providers who are on site in court. We refer cases, we accept cases. And right now, I'll talk about this again in a second, but we are actually piloting a shared telephone intake system with the other providers and a shared referral system. And so part of what we've tried to do with this new local funding, and it's taken us several years of conversations and visioning and really trying to figure this out, because coordinating across different organizations and bringing them all together is quite a puzzle. Is trying to work together so that tenants do not have to, go to 6 different organizations. They can enter through any one of those 6 organizations and get help potentially from whoever is available. And so you will often hear folks talking about shared intake models and saying no wrong door. You can go to any door to enter the system, but once you are in the system, we are all kind of spokes on a wheel, working together and talking to each other. And so that has been a big part of what Legal Aid has done with our eviction defense resources, along with these other organizations over the past couple of years. Next slide, please. And so what are we doing during COVID-19? And I will say the things here, other providers are doing similar things, and some of this involves that same coordination. So Legal Aid at the beginning, we set up a separate tenant hotline for tenants to call us. We have received over 500 calls since mid-March. Some of the key concerns we're hearing from tenants, of course, we're hearing about lost income and inability to pay rent and concerns about that. Tenants in subsidized housing have a lot of issues going on. And so part of the advantage of having a subsidy is you pay that income-based rent. And that means if you lose income, your rent is supposed to go down. But of course, that depends on the landlord or the subsidy provider, which sometimes is a government agency. getting that information, processing it, getting you a notice of your new rent amount. And as you might imagine, that's been very difficult during COVID times for all of that to work the way it should. So we are seeing those issues. Housing conditions, of course, are frequently an issue for tenants. But particularly right now, there are a lot of questions around access, around kind of under what conditions can the landlord come in? Is the landlord willing to come in to make repairs? And then we have seen, unfortunately, and all the providers have, an increase in illegal lockouts. So meaning a landlord who is just trying to change the locks, not go through the court process, and just kick a tenant illegally out of the unit. And part of why that's happening is some of the protections in local law that we have right now that are dramatically slowing down or stopping evictions and will for a long time. And so we're seeing more illegal lockouts. We're also just seeing threats from landlords. And we have actually been partnering with the Office of the Attorney General here in DC because they have been willing to intervene with landlords and make sure they understand they're breaking the law and that this is serious when they make these threats. I can say I am reviewing legal aid's intakes this month, and I've already seen, I think about 20% of our intakes so far this month have been individuals complaining about this kind of behavior. So, you know, we had a situation where locks were changed. We had a situation where a landlord told the tenant, you just have to leave, I want to renovate the unit, and then turned off the hot water and said, I'm turning off the electricity next. And we have another situation where the landlord said, I want you to leave, I just want to rent to somebody else. So I'm just going to start showing the unit. I'm just going to bring in people so they can look at the unit whenever they want, if you're not going to leave. And so those are the kinds of behaviors, unfortunately, we're seeing more and more of right now. The Landlord Tenant Legal Assistance Network is something that we launched with the 5 other providers on June 1st. And we're still building up volume on this, but what this is a shared phone intake system where we have a schedule and rotate who's doing the intakes. And then we can share referrals on the back end if the organization that does the intake cannot take the case. And so this is something that the court is providing as a resource to tenants and actually small landlords as well. And so now that we have this in place, the court is putting this on court notices. It's going to go on all the notices about upcoming hearings. They're going to incorporate it into a notice they send when a new complaint is filed. And so that is something where the court is just starting to put it on notices, but we are expecting that to become a really important resource. And then all of us are doing outreach. And so working with the court, we're recently able to get a list of all of the pending eviction cases. And we sent a first group of letters to tenants. We sent 300 letters. And then the next set, we're looking at sending about 3,000 letters. And these are for cases that are pending, but at initial stages. We're also working with the court to try to get contact information beyond just addresses. And so the court is getting phone numbers for all of these tenants to contact them about participating in a remote hearing. And we are trying to get access to that. So we also could potentially make phone calls. We've also been participating in a number of trainings, webinars, coalition meetings, and so forth. Next slide. And so I just wanted to share, when we're talking about eviction, just really quickly, an idea of the difference a lawyer can make. So in our Housing Right to Counsel project, we have kept track of cases where the tenant does get a lawyer and does not get a lawyer. And this is a project where we reach out to tenants and offer them representation. And if they want a lawyer, we provide it. We do not screen the case for merit, just make sure they meet our income guidelines. And so I'm just gonna summarize the numbers as opposed to repeating them, but basically tenants who get a lawyer get longer to get an outcome in their case. Most of those cases don't resolve on the very first day. It takes several months, and that gives the tenant time. I mean, I mentioned the lack of dignity and respect in the process, and frankly, it makes sure those tenants' voices are heard in the process, and there's a lot of value in that. They're much more likely to enter settlement agreements as opposed to judgments. When they enter agreements, they're much more likely to be able to comply with those agreements. And I think that just shows that these are fair, reasonable agreements that most tenants are able to follow. as opposed to, a one-sided dictated to you agreement that has really unreasonable terms that probably sets you up to fail. And ultimately, these tenants are much less likely to face eviction or the threat of eviction. Next slide. And you can go on to the next one. So just a little bit about what we're worried about is about to happen. And I just have a couple more slides and we're done with my part. So lost income, higher expenses. And I really want to emphasize both because I think part of what a lot of us and reporting around this, there's so much focus on lost income, and I think we may be forgetting that particularly for families who have very little cash income, the higher expenses, which many of us may be experiencing for various reasons, can be devastating to a family that has a really tight budget and really can't afford its expenses in normal times. But in terms of lost income, the census has been doing a survey that indicates that about half of district residents have lost income, about a quarter of them are reporting inability to pay rent. And we also have over 100,000 district residents who've applied for unemployment. And I think something that's important here is lost income may not be replaced. And so I think it's easy for us to think, well, there's unemployment, there's extra $600 a week. You see stories in the media about some folks are making, more money than they had before because their wages are so low to begin with. There are many workers who don't qualify for unemployment. Undocumented workers, for example, do not, and the council in DC is trying to scramble to figure out benefits for those families. But also individuals who were only employed for a short period before the crisis hit, and for other reasons may not be able to get unemployment. And of course, unemployment benefits, also there have been some federal extensions and expansions that are about to expire. And I think, frankly, we will just have to see what the Republicans in the Senate decide they're going to do about the crisis as it moves forward. But higher expenses, right? Food, when you're living in a food desert where there are no grocery stores nearby, you already find it hard to get affordable groceries. Transportation, public transportation has been way cut back. If you still need to go to work and rely on that, you may have to pay for transportation more than you normally would to get to work on time, to be able to get to a store and so forth. Uncovered healthcare expenses, and that can include funeral expenses. And something I didn't mention, but I know there have been a lot of news stories about this, is the reality that those being hit hardest by COVID, including in the district, are Black families, Latinx families, low-income families, individuals with disabilities, the households that already are often part of marginalized communities are facing many challenges before this crisis hit. And then utilities are another issue. It's summer. If you're paying for electricity to provide air conditioning, for example, if you're home more and using more water, and you have to pay for that. So next slide. So there are some protections. It's great. But my message on the protections to you all in the council has been that everything is paused, and that's really great. But pausing things is not the same as solving the financial problem that faced tenants. So right now we have no actual evictions, no new cases can be filed during the public health emergency or for 60 days. Right now in DC, the public health emergency lasts through July 24th. And we're expecting that to be extended. No rent increases for the public health emergency or 30 days, no late fees. And landlords are required to offer tenant payment plans for tenants who have some kind of financial hardship related to COVID for rent that's due right now and for 1 year after. They have to give tenants at least a year to pay back that money. And all of that is great, and all of it sounds great. But the bottom line of all of it is delaying the problem. And right now we really need the delay. And so it is wonderful that, unlike some other jurisdictions where eviction court has started back up in full swing and new cases are being filed, DC is going to have a longer pause. But at the end of the day, if we don't get financial assistance to tenants, it's not going to make a difference. in the end and what we see. And so finally, the last slide, if you can go to the next one, just in terms of what we might be seeing. So right now in DC this year, we've had 8,000 eviction cases filed, but usually by July, you would have seen 14,000. So we are already thousands of cases kind of behind, if you want to think of it that way. And if we saw, let's say, a 25, 50% increase, and it certainly could be more, that would be 40,000 to 45,000 cases filed this year. And so on the one hand, look, DC had filings at that level 10 years ago, and we didn't have as many legal services attorneys and pro bono attorneys. But the crisis, I think the real crisis is that they'll all be filed at once. And then I think a lot of these families, you know, are going to be in a financial crisis point when they are in court, and even more so than in normal times, unable to catch up on that rent without help. And I will just say, I will just mention the decrease, since I mentioned it, the decreased filings, I think actually is a bad sign that we used to be at 40,000 and we're down to 30,000. And it used to be 50,000. Phil may remember some years before that. Years before that used to be 70,000. I think what that actually is a marker for is fewer and fewer low-income households in DC that are renting. And so, for example, when I think about it, the past 10 years, case filings have gone down by 10 or 15,000. We've also displaced 20,000 Black residents from DC during that time period. And I don't think it's a coincidence those numbers are close. So, you know, we are losing low-income households from the district. Increasingly, folks are becoming homeless or are going to other places where they can try to afford to live. And as a result, we are seeing fewer eviction cases filed, is my opinion. And that's it for my slides. And I would love to just be quiet for a while and hear from Phil, because Phil is a wonderful speaker with many stories to share. And we wanted him to talk a little bit, and not just about, he has done, you know, housing work, but also has done other amazing pro bono work involving death penalty defense and a host of other issues. So Phil, I'm going to turn it over to you.
Can people see me having a, am I on? Or are you seeing a box of pepper?
We are seeing a box of pepper. We are not seeing you.
This has never happened before. This is very strange. I assure you that I am here.
Yeah, it seems like the camera is flipped around or something.
The camera has managed to reverse itself. Let me try something else. Does that help at all?
No, same view.
No. Darn, I've done a bunch of these and never had this happen. Aha!
There you are.
There we go.
Hello, Phil.
So the first question is going to be, do I look better or worse than a box of pepper?
I much prefer seeing your face.
Can we have the pepper back?
I do the thought of following Beth, who I have long regarded as the leading housing lawyer in DC, is actually kind of scary. Oh, there's an old friend, David Florin. Hi, David. So yeah, you're still on. Okay. So, so I'm not going to try to do what Beth did. I want to approach housing and eviction work in a very different way. I'm going to talk some about my experiences doing housing work, but first, and I think more importantly, I'd like to put all of this in context, both in a historical context and the context of what we see happening .
You froze.
Don't believe it is not white and you're not the owner. I was looking yesterday for an example of how far back I could take this. And I found an 1823 decision written by none other by two white men who would acquire lands from Native Americans. Here's how the Chief Justice described the rights of those Native American governments since time immemorial. And others.
Phil, I think we've been having some trouble hearing you. It might be that your internet is cutting out.
Any better?
Yes, we can hear you now. Well, it seems that it's cut out again. Phil, you might want to try turning off your video and just speaking and see if that helps the connection. Phil, we're still unable to hear you. It seems like you're muted.
We're not muting him, right? He's muted
No.
himself accidentally. Okay, just checking.
I mean, now.
It's still a little choppy. I wonder if you want to exit and try coming back in, Phil, and see if that helps at all. You also are muted at the moment, so I'm not sure we can tell.
Can you hear me now?
Yeah, now you are not muted.
Okay. It told me I was not muted. It lied to me. Okay.
Try now. You sounded clear for the last 10 seconds, so why don't you try now and see if it's better?
Okay, let me try again. I will not start over because I'm at a breakthrough. But the point of what I was saying is that the grounding of possession of rights of renters, that possession meant nothing and that ownership meant everything, especially if you had black or brown skin, goes way, way back in American history. And I want to talk about how that changed, because the fact is it changed right here in DC, in large part because one of America's civil rights heroes caused the change. His name was Skelly Wright, a native of New Orleans. He got his law degree at night, climbed the ladder of the U.S. Attorney's Office, and was appointed by President Truman as a federal judge, where he made waves, first by ordering the desegregation of Louisiana State Law School, then of LSU, then of the buses and parks of New Orleans, and lastly of New Orleans public schools. This made him the most hated man in New Orleans. Protection from federal marshals. More people named Kennedy rescued him in the early 60s by elevating them to the DC circuit. Around the nation in phrase with a slight change translation of "Let the renter beware." Substandard housing were the tenant's problems, and the tenant's obligation was to pay the rent or else, no matter what. But that changed under Judge Wright. Way. He rejected, instead of all residential leases in DC would be interpreted as containing an implied warranty of habitability based on the DC house. The extent that they was grounded in the teachings of the civil rights movement. He said racial and class discrimination mean that landlords place tenants in a take it or leave it situation. Poor housing.
We've had a little bit of trouble hearing you. I've just turned off your video in hopes that it might help the audio connection.
Okay.
You can keep going.
Is that any better?
I think it's going to be a little better, but you can keep talking.
I'll keep talking. Tell me if you can't hear. I apologize for this. As I said, I've done many of these meetings. This has never happened before. The rationale of Javins eventually spread around the country. The logic of John Marshall, that possession meant little and that all rights rested with the legal owner of the land, was gone. Now landlords had obligations. Tenants had rights, and they would get new ones, including in another groundbreaking decision by Judge Wright, protection against retaliatory evictions for insisting on their rights. This was nothing less than a legal revolution, but like most legal revolutions, it quickly ran into a problem: how to make these new rights a reality. One problem was bureaucracy, the scourge of all reforms. And here I'm going to get to some of the things Beth talked about. Simply put, while District of Columbia landlord-tenant law is progressive, the landlord-tenant court is not. Like all bureaucracies, much of what it does for its own convenience and for the convenience of the judges. Like all bureaucracies, it's highly resistant to change. And like all bureaucracies, when faced with a problem, it tends to take the course of least resistance. So here's some of what I've tried to do in response to all this. In the 1990s, I was a member of a task force of the DC Bar to study the landlord-tenant court, identify problems, and propose reforms, which we did. A few of the reforms were made, most were ignored. Years later, another task force called the Implementation Committee was convened. Beth is smiling, she remembers this. The executive director of legal aid was a member of the Implementation Committee. A few more reforms were made, most were still ignored. Today, people like Beth and legal aid are still pushing hard to reform this court, but it is slow going. In the meantime, despite the temporary pause that Beth mentioned due to COVID-19, the cases are going to continue, and they're going to come in a big flood, as she described. Which brings me to the second problem in implementing Judge Wright's legal revolution: the lack of enough lawyers to make the legal rights of tenants a reality. As she said, something like 90% of tenants in landlord-tenant court lack lawyers. This is actually an improvement from when I came to DC, when that number was 99%. We chipped away at it, it's down to 90% now. It's still a long way from where we need to be. We need more lawyers, lots of them, people like you. What can you do? One thing you can do is get involved in another project I was involved in a number of years ago when I was one of the leaders of a group that tried to set up something called the Landlord-Tenant Resource Center, which exists in court today, which is staffed by volunteer lawyers from law firms and government and by lawyers from the DC Bar Pro Bono Center, where people coming into court have some place to go, both tenants and poor landlords as well, where they can get some information. They don't get courtroom representation, but they can get some advice, some representation, some sense of what it is they're supposed to do. But that's not enough. What we need are lawyers to represent people in court. And the fact is that eviction work is perfect pro bono work for young lawyers or any lawyer with a busy schedule. The cases tend not to last very long or take up all that many hours. I've used 40 to 50 hours over a few months as a rule of thumb. There's a law to learn, but the learning curve is not terribly steep for most eviction cases. And you're almost certain to appear in court at least once. Imagine getting up in the morning, looking in the mirror, and seeing a courtroom lawyer looking back at you. So it's something most of you haven't experienced yet, but this is a good way to have that courtroom lawyer looking back at you in your mirror. And I can promise you, you'll have some of the most meaningful experiences and get some of the best stories to tell of your entire career. Let me tell you about a couple of my cases. I was briefly a full-time landlord-tenant lawyer in Boston in the early 1980s, where the law is quite similar to what it is in DC. And I had one case in particular. I was working for Greater Boston Legal Services, and a tenant came to me who frankly is not someone I wanted to meet in a dark alley. He was kind of scared. I liked his girlfriend a lot better. She was also living with him. They had lost their jobs, and they were living in what you would call a basement apartment of a private home. But basement apartment is not really fair. They were living in a hole in the ground. They had no electricity. They had no heat. They had no running water. They just had space, dirty, filthy space with nothing else. And they had not been able to pay rent for it for some time. If they had come to me earlier, I could have won this case without breaking a sweat. They had wonderful defenses. But they hadn't come to me. They had tried to represent themselves in the neighborhood courts of South Boston, Southie for those of you who know Boston, the poor Irish section of Boston. And they had lost, and they had a judgment of eviction and a judgment for a lot of back rent staring them in the face and no place to go. That's when they came to me. Under the laws of Massachusetts, the only thing I could appeal, but the only way I could appeal was if we could post a bond to cover the cost of the back rent, and they didn't have the money to post the bond. So I did the only thing I could do, which was to file a motion to waive the bond, which the trial court had the right in its unfettered discretion to do or not do. So one morning I went down to the South Boston courthouse to argue my motion to waive the bond. I didn't think it would be granted. Wasn't that optimistic. My hope was simply that the judge wouldn't deny it from the bench and would keep the case alive long enough for me to work out some kind of settlement. And sure enough, that's exactly what he did. He looked very skeptical about my motion, but at the end of the hearing, he said he would take it under advisement. I and the landlord's lawyer and the landlord's wife, the landlord himself, the principal landlord had not shown up. He had sent his wife instead. She was a much more presentable person. And my two clients walked out into the hallway where the landlord's lawyer proceeded to scream at me, told me that I needed to grow up and be a man, and that my clients needed to grow up and be a man and just move out of the house right away, move into the YMCA, sleep on the street. He didn't care. They were wrong. They hadn't paid the rent. They needed to get out. His clients needed the money. And while this was going on, I was looking at the two women, my client's girlfriend and the landlord's wife, and the two of them were standing there with tears in their eyes. And the girlfriend said to the client's wife, to the landlord's wife, "I want to pay rent, but I don't have the money right now. And if we lose this place, we're going to sleep on the streets." And the landlord's wife, with tears streaming down her face, said, "I don't want you to sleep on the street, honey, but we've got to have some money or we're going to default on our mortgage and then we'll be on the streets." So I had an idea. This was thinking on your feet. I maneuvered the two women around one corner of the hallway, and I maneuvered the landlord's lawyer and myself around the other corner. And then I goaded him into yelling at me some more. And he obliged, and he yelled and screamed for me to be a man. People were peeking their heads out of the hall, down the hallway, looking back. What the hell was going on down there? My purpose was to get him away from the two women in hopes that they would actually settle the case, which they did. 5 minutes later, they came back and had a wonderful settlement, far better than anything I could ever have gotten from the court. I tell you this to say that if you're going to practice this law, as I say, you will get stories that we'll see a real world, which is, let me tell you about one more case. This was actually a legal aid case that was handled by an associate at my firm that I supervised. We have a program with legal aid, the Loaned Associate Program, where we send those for sign and become what it term with. And I talk about this case because it is symbolic of what Beth described with some of the problems that we're facing now, the loss of affordable housing, gentrification. Across the city, slumlords for years have been pushing tenants out and then flipping their properties to developers at large profits. Developers then turn them into luxury condos for, frankly, people like us. In many ways, it's been great for the city, but it's been terrible for the city's poor, who have been squeezed either out of the city or into ever worse and ever smaller areas where they are looking desperately for housing. And some landlords will stop at nothing to try to clear out their buildings to make them easier for sale. That's what this landlord had done. He had made the building so miserable that all of the tenants, save one, had left, David's client. He turned off the power, the electricity. David's client stayed. He turned off the water. David's client stayed. And then the day before a court hearing in the eviction case involving David's client, he sent some, there's no other word for it, goons to the client's apartment. They went in, literally ripped the toilet off the bathroom floor and left it lying in the middle of the living room floor. The next day, David came up before the judge and was describing the sort of things his client had had to put up with. The judge looked like she wasn't quite sure whether she was believing this or not until he got to the story of the toilet having been ripped off the floor and left in the middle of the living room. And to David's surprise, the judge said, "That's it. We're going to have a view of the scene. Come on, everybody, off to the cars." So the judge and several courtroom personnel and the lawyers and the clients piled in their cars, drove off to the building, and the judge led them up the stairs and into the apartment, and sure enough, there was the toilet lying in the middle of the living room floor. As you might imagine, the rest of the hearing did not go very well for the landlord. And the denouement of the case was that David took it to trial and secured a judgment of $150,000 in punitive damages for what the landlord had done, which legal aid was pretty confident was the largest punitive damages award ever given in a residential housing case in DC. I tell you this case to give you some sense of just how bad it is out there, just how badly lawyers are needed, and what you can do, and the things you can do that will stick with you for the rest of your lives, far long after your commercial cases have left your memory. So let me end where I began. I want to stress the link between housing work and racial justice. As Beth said, this is an incredibly strong link in a house where most of the tenants in landlord-tenant court have black or brown skin. For many people today, working for civil rights means braving COVID-19, standing on the streets with other people, carrying a sign and shouting out to passersby, "Black Lives Matter." That's great. That's inspiring. That is courageous. But for us as lawyers and soon to be lawyers, it is not enough. Lawyers need to come in from the streets and into the courtrooms where they can demand that judges prove that Black Lives Matter to the justice system in ways that they have not done so before. That is your charge. I believe that each and every one of us has a moral obligation to do this work. If not through landlord-tenant work, than through using your skills in some other way to plug the justice gap. A few minutes ago, I told you that this work will allow you to look in the mirror and see a courtroom lawyer looking back at you. But there's something else that you might see. I've been a lawyer for exactly 40 years, most of them as a partner at Arnold & Porter. I've practiced commercial law at its highest levels. I've traveled the country and in fact the world to do that. I've worked on cases that have made headlines, and I've made a lot of money. To all outward appearances, I was a success. But if I hadn't spent thousands of hours doing pro bono work, including landlord-tenant work, when I looked into that mirror in the morning, I would see something else. I would see a failure looking back at me. Don't ever take the chance of seeing a failure when you look in the mirror. Join with us. Do this work. And if you do, but only if you do, you'll see a success looking back at you. I apologize for all the technical problems. I thank those of you who stayed with me. And Beth, I'll hand it back to you.
Thank you so much, Phil. You're always, everything you say is always so beautiful and inspiring. I really appreciate it. We only have a few minutes left, but I can stay on a little bit longer. If anyone has questions, comments, anything that you, that is on your mind to talk about today, feel free to put something in the chat box or just unmute yourself and ask a question.